Welcome to Emphasis Added, a podcast brought to you by the Houston Law Review about legal issues, prominent lawyers, and the study and practice of law. I'm Harrison Little.
And I'm Jake Guarino, and we are your hosts for Season 5. Thank you for joining us. We're joined here today by Professor Emily Berman from the University of Houston Law Center. Her scholarship examines the unique separation of powers challenges that arise in the constitutional, statutory, and regulatory regimes governing national security policy. Her work has been published in several top law journals, and her opinion pieces have appeared in numerous national media outlets. She particularly focuses on traditional government oversight measures such as electoral accountability or separation of powers, and how they are implemented during law enforcement and intelligence operations.
Professor Berman attended NYU School of Law, where she advocated for different civil liberties initiatives affected by U.S. national security policy for fellowships with the Brennan Center for Justice and the Furman Academic Program. After graduating from NYU, Professor Berman clerked for the Honorable John M. Walker, Jr. of the Second Circuit Court of Appeals. Then she joined the University of Houston Law Center faculty in the fall of 2014. At UHLC, Professor Berman teaches national security law, foreign affairs law, and constitutional law. Professor Berman, thank you for joining us today.
Thanks for having me.
So today we're talking about the Colorado ballot case, or Trump v. Anderson, and during an important year for American politics, the 2024 election. Could you please provide some of the factual issues as well as the legal points and the overall general holding that the court arrived at during its opinion?
Sure. So the case arose out of a challenge in Colorado by some voters to the fact that President Trump was on the primary ballot for the Republican presidential primary. And the substance of their challenge was that based on Section 3 of the 14th Amendment, he was ineligible to hold the office of the presidency. And I won't read it word for word, but essentially what Section 3 does is it says that if you have previously taken an oath to defend the Constitution and subsequently engaged in insurrection, then you are disqualified from holding a future office under the United States. And so their theory was, based on his involvement in the events of January 6th, President Trump was engaged in insurrection. He had previously taken an oath to the Constitution when he was in office, and therefore he was not eligible to be president again. The Colorado District Court agreed with most of what the challengers had said, except he decided the case on this sort of formerly obscure argument that the presidency is actually not a, quote, office under the United States. And we can talk a little bit about that if you want to. But then it went up to the Supreme Court of Colorado, and the Supreme Court of Colorado said, actually, we do think the presidency is an office under the United States, and we agree that President Trump engaged in insurrection, and we agree that he should be disqualified from the ballot. So that is the case that was then appealed to the Supreme Court, and the Supreme Court essentially said in a case that was 9-0 in the judgment, they reversed the Colorado Supreme Court and said, no, we think President Trump can, in fact, be on the ballot. He is eligible. And the meat of the reasoning was that it didn't make sense to the court that individual states would have the power to decide who was eligible for the federal presidency. So they determined that it was a matter of the president represents everyone, and therefore it doesn't make sense for states to be able to have, they call it a patchwork of different rules, where some states might determine that he didn't engage in insurrection, other states might determine he didn't, and that's not how it should work in a presidential election.
And so it sounds like Section 3 of the 14th Amendment is kind of at the center of all this. So at a very general level, it seems to have three major components. That first, it applies to a specific class of individual, that it then imposes a severe penalty on those individuals, And then it also provides a means of lifting this penalty. So could you provide some elaboration on the intricacies of Section 3 so that we can better understand its function and operation?
Sure. So it starts off with a list of offices that are going to be covered by this provision, and includes pretty much every federal elected office, as well as civil or military office, as well as state offices. If, as an officer of the United States or any member of a state, so if you were an officer of the United States or you held office under a state government and had taken an oath to defend the Constitution, then engaged in insurrection, then you were not eligible for any of these particular offices. And then at the end, it says that Congress can eliminate the disqualification of anyone who does qualify under all of the requirements of Section 3 by a 2/3 vote of each house. So in other words, even if based on the bulk of Section 3, you meet all of those requirements and you are in fact barred from the ballot, Congress can decide, well, we want to let you hold office anyway, so long as there's a 2/3 majority in each house. And one of the things that the concurrence points out is the last sentence of Section 3, which says, but Congress may, by a vote of 2/3 of each house, remove such disability. Seems to assume that the disability is already there, and then Congress can take action to lift the disability. So, according to the concurrence, that means that Congress shouldn't have to do anything to impose the disability to begin with, that the disability should come from sort of automatically because you broke the rules. And whether that is the case or not is really why the concurrence is a concurrence and not actually joining the full opinion.
So most of the tension in this case then stems from the issue of line drawing between federal enforcement and state enforcement of Section 3. Based on how the court held in its case, can states enforce Section 3 of the 14th Amendment on their own? And if so, to what extent may they do so?
Yeah, so the court said that states can enforce Section 3 of the 14th Amendment when it comes to state officials. So when they're deciding how to determine whether someone can be governor or be seated in the state Senate. In those instances, the states can decide how they want to implement Section 3 of the 14th Amendment. But when it comes to federal offices, they say, and especially the presidency, because it's elected by the whole country, in that instance, the states are not allowed to impose rules based on Section 3. Those would have to come from Congress.
And that sort of gets back to the concept that you mentioned earlier of it being a patchwork problem, where if we allowed states to disqualify candidates for federal office, then states would, inevitably apply different standards and do that in different manners, which would then disrupt the federal electoral process. Is that kind of a good summary of how this patchwork problem arises?
Yeah, I think that's right. Is that they talk about, one state might decide that you have to have been an insurrectionist by a preponderance of the evidence, where another state might decide that there has to be substantial evidence, or they might have different procedures with how to make these decisions, and that doesn't make sense for a national election. The odd thing about that patchwork argument, though, is that states are in charge of their own ballots and their access to ballots, and the rules about access to ballots are different from state to state, how many signatures you have to get, or how big a percentage of the last vote your party had to get to have a space on the ballot. And so why it would be okay for example, a third party candidate that gets on the ballot in some states and isn't able to get on the ballot in other states, why that's okay, but it's not okay if that happens with a candidate for one of the major parties.
And so this logic would apply in terms of federal enforcement, state enforcement, and the clear federalism line that you're drawing. How does this come into play with, say, a congressional seat, when it's a state representative elected by state constituents, but also going to serve the interests of that state at the federal level?
Yeah, so what this court seems to say is that in order for this to be enforced at the federal level, it has to be enforced by Congress. It can't be enforced by the states. So even though the states can decide this, we're going to enforce it when it comes to our own legislative, the state legislature, when it comes to the federal legislature, only Congress can decide what those rules are going to be.
So it's similar to how you would remove a member from Congress for bad behavior, for example.
Yeah, it is, except that Congress does that on sort of a case-by-case basis. We just recently saw it, right? George Santos, someone can be expelled from Congress because they decide that they don't want them there. Either house can refuse to seat someone if they think that they haven't met the qualifications. And it's not clear that if the court has that in mind. What they seem to have more in mind is an actual statute that says, here's the definition of insurrection, and here are the processes that you have to go through to determine whether someone engaged in insurrection, and here's the standard of proof. And so they point to, there is in fact a criminal statute for engaging in insurrection. It's a crime. And that statute says if you're convicted of insurrection, then you are not eligible to hold office. And so the court points to that and says that is one mechanism through which Congress has implemented the Section 3 of the 14th Amendment, through this criminal provision. And presumably, they could also do it through some civil provision, and they could set up however they thought that should play out. In the post-Civil War days, it was often implemented by the U.S. attorney would bring an action in federal court, basically arguing that the person was ineligible because they'd engaged in insurrection. So the court wants Congress to be the one to decide how to implement the rule, and they seem to have in mind Congress doing so through legislation. The big question that this case leaves open is, what if Congress decides that they want to enforce Section 3 of the 14th Amendment on January 6, 2025, when they're counting electoral votes? Because there, Congress decides to accept electoral votes as validly cast. And you can imagine members of Congress objecting to accepting electoral votes for Donald Trump on the grounds that he's not eligible to serve as president. And while that is a very unlikely scenario to happen, because if President Trump has actually won in the Electoral College, most likely Republicans are also the majority in both houses of Congress, and so, or at least one of them. And so it's unlikely that this would actually come to pass, but it is one of the questions that's out there is, okay, you say Congress has to be the one to enforce Section 3 when it comes to federal officers. Well, does that have to come through legislation prior to the election, or can it come afterwards in the form of objecting to electoral votes? Another way would be, what if Congress said, the new Congress passed legislation saying that no administrative rule implemented by an insurrectionist is valid because that person is not eligible to serve in the office, and therefore any official actions that they take is invalid. And then anyone who's subject to a federal regulation could bring a suit under that statute and say, I don't have to pay my fine to the EPA because this enforcement action was taken by an invalid executive branch. So part of what has really confounded people about this opinion is that, yes, they're very clear it has to be Congress, but they're not as clear about exactly what context Congress has to be acting in. And so it leaves a lot still up in the air.
And so the court spent a substantial portion of the opinion analyzing the relationship between Section 3 and Section 5. Would you explain how these two sections interact and how this relationship shaped the majority's reasoning?
Yeah, so Section 5 of the 14th Amendment is the provision that gives to Congress the authority to enforce the substantive provisions of the 14th Amendment. So the first four sections lay out rules, and Section 5 says Congress has the power to enforce these rules. And what the court has decided in cases involving enforcement powers under Section 5, not to do with the ballot access or anything, but just in other enforcement contexts, is that Congress can pass legislation that is what the court calls congruent and proportional to the violation of the 14th Amendment that Congress is trying to prevent. And what exactly it means for something to be congruent and proportional is something that we can argue about, but the court made very clear that that line of doctrine, that the enforcement mechanism has to be congruent and proportional, that would apply to anything that Congress did under to enforce Section 3. The other way that the court used that is essentially the 14th Amendment was put in place to impose limits on things that the states could do, right? The Section 1 of the 14th Amendment says no state shall, deny any person equal protection of the laws, for example. And so here the court said the 14th Amendment was designed to constrain state power, not enlarge them, and to give Congress the authority to decide how that was going to happen. And therefore, it wouldn't make sense, this is sort of another argument about why the states shouldn't be allowed to disqualify anyone. It wouldn't make sense for the states to have broad authority to enforce Section 3 against federal officers because the Constitution gave the enforcement authority to Congress, not to the states.
And so the majority accuses the Colorado Supreme Court of applying sort of a inverted view of the 14th Amendment. Would you elaborate on what they're really getting at when they say that?
Yeah, they're saying that if what you say is that the states have unfettered authority to just decide what the 14th Amendment is going to mean for them, which is essentially what they're arguing is the states should be able to decide how to implement this limitation on access to the ballot. on a state-by-state basis. The court's saying that's not how any other part of the 14th Amendment works. The 14th Amendment limits state power. It doesn't grant states power. And the implementation comes from either the courts or from Congress. It doesn't come from the states, because the whole point of the 14th Amendment was that the states had behaved badly and we wanted to place some limits on what they could do. And so the majority is essentially saying, if we have a constitutional amendment that's designed to limit what states can do, then it doesn't make sense to interpret it in such a way that they can decide how they want to enforce it themselves.
So would you say that the argument is similar to the McCullough v. Maryland tax argument, in which there was the state of Maryland was trying to tax the national bank, and so it's kind of a supremacy clause issue there?
Yeah, to a certain extent, because they did say something similar to, in McCullough versus Maryland, the court said, the bank was enacted to serve everybody by the federal government, and therefore one state, in that case Maryland, shouldn't be able to impede the bank, because that's taking the people of the state of Maryland, imposing their will on the rest of the country. And that does seem to be part of their argument about not letting sort of different rules apply in different states, because we all vote for president, and president represents the whole country, and therefore you shouldn't let individual states keep that person off the ballot and essentially undermine the country's ability to act as a whole to choose who the president's going to be.
So up to this point, we've talked a decent amount about how the majority arrived at their legal conclusions. So I was hoping that we can talk about the concurrences a little bit more, because it gets a little bit juicier once you get there,
right?
Especially with Sotomayor's concurrence. So the concurring justices object to the majority's conclusion that the power to enforce Section 3 against candidates for federal office lies strictly with Congress.
Thanks for listening. Emphasis Added is a podcast brought to you by the Houston Law Review. If you like what you see, check us out on Spotify, YouTube, or your favorite podcast streaming app for new content when it drops.
Follow us on Instagram at EmphasisAddedPod, or check out the Law Review at HoustonLawReview.org.